Hello, everyone. Let me first say I hope everyone is doing well. I also want to give my heartfelt prayers to everyone in Texas, those who have lost a loved one, those who are still searching for their loved ones. My heartfelt prayers go out to everyone in Texas or those who have loved ones or family members impacted by the tragic flooding. Hey guys, I want to talk about two updates that I want to share with you. Number one, July 4th, President Donald Trump, he signed into law the Big Beautiful Bill. Now, in the bill, we've heard throughout the news and social media the cuts that would be made to Social Security and other social programs. Well, there were also other things in the bill that affect immigration, and that is fee increases, and in some cases, new fees on applications that never had a fee. So I want to run down for you just really quickly a few of the fee types and the cost or minimum fee amount and whether or not they're waivable. So in the Big Beautiful Bill, there is now going to be a $100 application fee for asylum, the asylum application, the I-589. Previously, there was no fee associated with filing an asylum application. By the way, that $100 fee is not waivable. Also, with an asylum application, your first work permit didn't have a fee associated with it. Well, in the Big Beautiful Bill, that first work permit that you apply for with your asylum application, there will be a fee and it's $550. Again, you cannot file a fee waiver for that. Let's turn over and let me share with you fees for TPS applications. The minimum initial fee amount is now $500 and that fee is waivable. If you are in immigration court and you have a defense of cancellation of removal for a green card holder, that fee is now $600. And if you're filing cancellation of removal for a non-green card holder, that fee is $1,500 and that fee is waivable. Also to note, if you're in immigration court and you lose your case, there is now a fee of $900 if you want to take an appeal to the Board of Immigration and Appeals. Also, if you have an old removal order and you want to reopen your old immigration court proceedings or BIA, if you filed an appeal, if you want to file a motion to reopen, that is now at a fee of $900 and that's also waivable. Guys, these were just some of the highlighted fees I wanted to share with you. A few takeaways I want to leave with you regarding this update, and that is it is highly likely lawsuits will be filed concerning the fee increases and certainly the fee for filing an asylum application. It should be noteworthy here to note that last year, about a year ago, fees increased under the prior administration. And I believe there was litigation concerning those fees as well. And here it is, a year later, there's another fee increase. So I wanted to share that with you. We will be on the lookout with regards to whether there'll be changes to these fees if, in fact, a lawsuit is filed. Now let's turn our attention to something else that we shared with you. You'll recall we gave you an update that Florida's Attorney General, James Uthemeyer, he made application with the Supreme Court wanting to have the Supreme Court to lift the trial court order that basically said the state of Florida could not enforce the law of SB 4C. Now, that law is the law that says if you enter the United States illegally, unlawfully, and then enter the state of Florida, that is a crime. The trial court in that case placed a order that blocks the enforcement of that law while the lawsuit is still ongoing. Well, Attorney General Uthemeyer applied to the Supreme Court, asking the Supreme Court to lift the order and allow the state of Florida to be able to enforce that law. Well, guys, the Supreme Court has denied the request. Now, I got to be honest with you. I was kind of surprised to learn that the court declined to grant the application to allow Florida's AG and the state of Florida to enforce the law of SB 4C. Share your thoughts with me in the comments. Are you surprised as I am? I'm not sure if this is an indication the Supreme Court maybe may not be so willing to just grant applications that want to have the trial court level orders undone so that laws or policies can go into effect. But for the state of Florida, its application to enforce SB 4C, the Supreme Court has denied the request. So, as the underlying litigation continues to unfold, we will certainly continue to update you with the status of that. Guys, thank you so much for watching. Please be sure to like, share, and subscribe. To all individuals in the state of Texas, our heartfelt prayers go out to you. Guys, be safe and be well, and I will see you in the next one. Bye-bye.